Hi, I'm Jonathon Kappy.
And I'm Nick Esterbauer.
Welcome to Holland Estates. You're listening to episode number 599. So today we are going to discuss the case of Robert Mandel and 1909975 Ontario Inc., which is a great case for me because it gives us a chance to look at a principle that we see in an estate context, but we get to see how it's used in another context, which sheds some additional light on the equitable principle of rectification. I think there are, we'll talk about the facts in a second, and I think there are three grounds which the judge declines to give the relief that's being sought. But I think we're going to focus on the rectification issue, because I do find that the most enlightening in terms of the wills and estates practice.
For sure.
So let's just get some basic facts out of the way. The court makes very clear in a number of places that context is everything. So let's give some context to what we're going to talk about. We're talking about essentially a tax rollover, all right? And so what happened was that there was a successful company held in a family trust. And the 21-year deemed disposition was approaching. And so the heads of these two families, Robert Mandel and Ellen Pike, decided to implement some tax rollovers in order to defer that tax. And so what they did was they created a holding company as between the operating company and their children. And what they did essentially was they transferred the common shares of this holding company to the children, and they themselves retained the Class A voting shares, a set of 100,000 Class B convertible shares, and then those children got 100 common shares. So essentially what happened was that these heads of the family, this Mr. Mandel and Ms. Pike, retained the voting control over those holding companies, which the court refers to as the child corporations. They also had these Class B convertible shares, and while those children got 100 common shares. And the purpose was to roll over to the children so that you could defer the tax. Interestingly enough, I do want to comment about the Class B convertible shares because I find it a fascinating way to do things. It didn't necessarily work out in this particular case. But what they had done was they were worried that in the future there may come a time where these children get married, they get divorced, they have to worry about equalization and things of that nature. And so those Class B convertible shares were convertible into those common shares. So that if ever such a time came, those Mr. Mandel and Ms. Pike could convert those Class B shares into 100,000 common shares, which would dwarf the 100 shares that were held by the children and therefore dilute their interest. Not necessarily relevant to the issues in this particular application, but I thought it was a great idea, and I'd never seen that before.
Absolutely. So it sounds like a very complicated transaction that happened here, but it's dealing with, I guess, mechanisms we often see for dealing with family businesses. We've got family trusts, we've got family corporations, and a transfer to, in an attempt to avoid this deemed disposition and the taxes that are going to be triggered by that.
Right. And so after having implemented all of that, CRA came back and reassessed them and determined that because Mr. Mandel and Ms. Pike retained control over these child corporations, that the income should be attributed to them, and they got each hit with a $15 million asset or income. And so therefore they didn't appeal, but what they did was they brought an application before the court on the commercial list for a declaration that they were in fact never the controlling shareholders of these child corporations. And the basis that they did so was the fact that although the register of these corporations showed that they had the voting control over these corporations, because they never actually paid for the shares by the terms of the Ontario Business Corporations Act, that transfer was invalid. And so notwithstanding that they had subsequently corrected it, and now that the children were in fact the controlling shareholders of these child corporations, they sought a declaration that Mr. Mandel and Ms. Pike were never the controlling shareholders of this corporation. And as we'll see as we go through the decision, it really looks like they were trying to do an end run around this tax decision for a declaration that they were never the controlling shareholders, and therefore this tax shouldn't be attributed to them.
So the court did review some of the conflicting evidence that was present here. The corporate documents themselves refer to them as being shareholders. The main argument, as you mentioned, Jonathan, was that under the Ontario Business Corporations Act, they couldn't have the shares issued until they'd been paid for. And that's something that I think was really relied upon in their argument, seeking that declaration.
Well, listen, I think that the court breaks it down in a number of ways. And I think at first the court talks about jurisdiction, right? And the court says, listen, when you're talking about jurisdiction, you're really, you have to look at context. And in this particular case, there is no legal dispute. I mean, everyone came to court, the children, Mr. Mandel, Ms. Pike, everyone agreed that this declaration should be granted. So the court said, well, what am I really being asked to do? This has been fixed. If there ever was an issue with respect to who should control this company, it's now been fixed. The corporate register has been fixed. So why are we here? What are you really asking me to do? And what you're really asking me to do is to make a decision that you're going to take to the tax court to try to get around your tax reassessment, when really what you should be doing is appealing the tax decision directly to the tax court. And so the court on that basis declined jurisdiction. The court found that, for tax purposes, this is what you're really asking me to do, and that you're better off going to the tax court. And, Justice Conan refers to an earlier decision of Justice Cumming, which I found was right on point, and the judge found which right on point, which was where Justice Cumming said, in my opinion, the only real purpose in bringing this application is to influence or upset the hearing before the tax court. The applicant, in effect, seeks an opinion of this court under the guise of a declaratory order in order to place that opinion before the tax court of Canada in the tax hearing in the appeal. So I think that the judge in this particular case found that that was sort of on all fours with what was going on in this particular case. So those were some of the reasons that the court declined jurisdiction. The court also said that because the corporate register had already been fixed, there was no prejudice in him declining to make the declaratory order. There was no outstanding issue, really. They were looking for a retroactive order that had no real purpose other than for the tax appeal, which I note that they had not appealed by the time of this decision. At least the judge wasn't aware of one. But then the court gets to the issue of rectification, which I find was fascinating, because the parties refer to Section 250 of the Business Corporations Act that says that where there is a wrong, where something has been omitted or wrongly deleted, one of the parties, whether it be a security holder, the corporation, or an aggrieved person, may apply to the court to have the register rectified. And it was first their argument that the rectification that's provided for in the context of that statute is different than the equitable remedy of rectification that's generally available, which is what we see often in the will and estates context. And the court said, no, I don't think I agree with you. The court said, just because an equitable remedy is reduced to writing in a legislation doesn't change the nature of the remedy. We're still talking about the same remedy. And so the court started on that basis. All right, the remedy that we use for rectification of a will is the same remedy of rectification in the context of a corporate governance.
I found that particularly interesting, Jonathan, the fact that there's so much in common when you're applying rectification to this context, where it's also set out in the legislation, versus the rectification of a will. You're still looking at the same things, the intention of the parties, or in the case of a will, the testator, and whether or not there's been a mistake made so it doesn't reflect the intention at the time that the documents were signed.
Mm-hmm. Yeah. And what's interesting is also, I find that when you're talking about a will and rectification, we all know that the rectification involves what did the testator intend at the time that the will was made. That sort of, goes without saying. But the court takes that head on in the context of this decision. And the court refers to a great decision of the Supreme Court of Canada, which is called Canada and Fairmont, where in a situation similar to this one, Fairmont, who was a taxpayer, had implemented a tax plan that it thought was going to be tax neutral. It turned out not to be tax neutral. And then they sought to rectify that to basically go back to the beginning and start again. And the Supreme Court of Canada said, no, you can't do it that way. And the court made a really great statement that really clarifies what rectification is, when it can be used. And I'm just going to read it quickly because I think it goes to the heart of this issue. And the court said, it bears reiterating that rectification is limited solely to cases where a written instrument has incorrectly recorded the parties' antecedent agreement. It is not concerned with mistakes merely in making of that antecedent agreement. In short, rectification is unavailable where the basis for seeking it is that one or both of the parties wish to amend not the instrument recording their agreement, but the instrument itself. So rectification isn't available to fix a mistake where the actual plan was the mistake. Mm-hmm. Rectification is only available where the parties recorded that plan or recorded that agreement incorrectly, such that the agreement needs to be fixed.
Which again is the same as my understanding in the wills and estates context when you're looking at the rectification of a will.
Yeah, absolutely. If the testator, wanted to do something that had poor ramifications, all right, the court's not going to rewrite this person's will. The court, in terms of rectification, will only fix a will to the extent it's necessary to give effect to the intention of the testator. Whether that has a good outcome or a bad outcome, that's the limited scope of rectification. And the court in this particular case does the same thing. If you intended to have, Mr. Mandel and Ms. Pike being the controlling shareholders, I'm not going to fix that if that was your original intention. If it wasn't your original intention, that's a different story. But if you're trying to fix a bad plan by rectification, the court's saying, that's not what this equitable remedy is for. I think ultimately the court basically says, I'm not making any decision on it. I'm declining to make a decision. Your proper forum is to go to the Tax Court of Canada and appeal the reassessment. So it remains to be seen whether rectification will be granted. But I certainly think that in light of Justice Conan's decision, they're going to have a hard time convincing the tax court that it should be.
Absolutely.
So I like that decision. It really gives some additional context to the remedy of rectification. It allows us to look at it through a different lens, but it is the same principle. And certain things that we take for granted in the will context are not taken for granted when you're talking about it in a corporate context. So something to think about. And I guess that concludes our podcast. Until next time, we want to thank you for listening. I'm Jonathon Kappy.
I'm Nick Esterbauer.
Should you have any questions, please email us at webmaster@hullandhall.com or leave a comment on our blog. Thanks for listening.
Thank you.